Hi, I'm Ray King. I'm an attorney here at Woods, Rogers, Vandeventer, Black with Vanessa, and we do regularly practice together. I'm going to be discussing commercial foreclosures today, specifically talking about some tips that will be useful to you in your commercial foreclosure practice and traps to avoid during your commercial foreclosure practice. And commercial foreclosures are different from residential foreclosures in several significant respects. First, in commercial foreclosures, there are not as many debt collection hurdles or laws that come into play since it is a commercial and not a consumer or residential transaction. And secondly, you deal with many different types of real property, not just with residential or units of residential real property. So there is a degree of difference in commercial foreclosures. One of the first things to consider when you're embarking on a commercial foreclosure practice is the role you're going to take. And I've been employed in two distinctly different capacities over the 20 years or so I have practiced commercial foreclosures. You can be the attorney for the lender. And as the attorney for the lender, you're guiding the entire process, advising the lender, and you can also serve as the trustee, or you can employ the trustee. I've also been engaged solely as the independent trustee, where I'm working for the attorney who represents the lender and obviously taking guidance provided by the lender. But I'm not representing the lender in the transaction. Under Virginia law, there is not a prohibition on an attorney serving both functions at the same time. That is, being the attorney counseling the lender on the foreclosure process and at the same time serving as the trustee and foreclosing on the property. There are a couple of caveats, though, you have to pay attention to. If you are the trustee as well as the lender, counsel for the lender, you cannot give the lender advice on how to bid at the sale because that violates the trustee's duty. Whereas if you're simply counsel for the lender, you can provide that advice. That's one of the things you need to be acutely aware of. Second, there are circumstances where you may not want to serve both roles as a practical matter. If there is a particularly adversarial or contentious relationship between the borrower and the lender, it's always a good idea that if you're going to be the trustee, you be independent and you not also be lender's counsel for the transaction. You want to be able to exercise your discretion and your duties independently and not represent the counsel, because if there's a lawsuit, it's much cleaner if you are, in fact, independent. One of the other things you're going to come across in commercial foreclosures is that you can have portfolio loans where you have a single loan or a package of commercial loans that are secured by multiple properties, and you could have a situation where the lender wants to foreclose on 3, 4, 5 or more properties at a single time to collect money due on a commercial loan. This can be done, but you have to pay attention to the advertising requirements. You have to pay attention to the jurisdictions in which you must advertise the sale, because if you have properties in separate jurisdictions, you could end up having to advertise in a separate jurisdiction for each property. And then you need to schedule your sales accordingly. So if you're going to do them all in 1 or 2 days, that you have travel time between the sales to get from one sale to another. I have done as many as 10 or 12 sales in a single day in 5 or 6 different locations across the state. It is purely a matter of scheduling. With the first sale starting at 10 in the morning, we wrapped up the last sale after 4:30 in the afternoon. It can be done. And when you're doing portfolio sales, remember you have to file a final accounting in each jurisdiction in which you do a sale. So you can end up filing 4, 5, or 6 final accountings with different commissioners of account. And since you have to produce the original note to each of the commissioners, you have to set up a process for moving the note from one commissioner to another and keeping them advised as to what's going on along the way. When doing commercial foreclosures, as I mentioned, you can also be foreclosing on a wide variety of types of property. You could have, for example, an apartment complex you're foreclosing on. You can be foreclosing on a warehouse, a church, a manufacturing facility, and so on. There's almost no end of what you can be foreclosing on. Some of the properties you may be asked to foreclose on are properties of limited or special utility. And what this does is it reduces the available bidders or buyers in the market who would be interested in this property. If that's the case, you need to think about what you can do and, as the trustee, have a duty to do to encourage more bidders to participate in your sale process. There are a couple things you can do in this regard. First is you may have to consider advertising your sale outside of your immediate geographic area and advertising it, say, for example, across Virginia or across the East Coast. I've had sales that were in the Tidewater, Virginia area that I advertised in the metropolitan DC area because I felt there were more potential bidders in that area. And I've also advertised sales in New York because that is a market that could attract more investors who would be interested in purchasing the property. In addition, if you have a unique property, you may want to consider hiring an auctioneer who specializes in that type of property to call the sale for you, because by doing so you will get access to the auctioneer's mailing or distribution list. An example is I have sold several marinas at foreclosure sales. Marinas are definitely unique properties, water dependent, and the parties who are interested in marinas are not solely located locally. They're all up and down the East Coast and the Gulf Coast, at least with ones who would be interested in buying property in Virginia. An auctioneer who deals with those sorts of properties has a list of customers who can bid, and I have been successful in the past in attracting out-of-town bidders at those sales by using an auctioneer. When entering into your agreement with the auctioneer, it is important to make sure that the auctioneer knows that it is your decision to sell the property, not the auctioneer's. The auctioneer's decision is to get the highest and best offer through the bidding process at the sale until you're satisfied that you've got a high bid and you can knock down the sale. You do have alternatives other than foreclosing on property in commercial deals that may not always be available in a residential proceeding. One is if you have an income-producing property such as a shopping center, a self-storage warehouse facility or something like that, you may seek to have a receiver appointed who would collect all of the rents and revenues generated by the property and turn them over to the lender. In many instances, the receiver can generate enough cash flow to service the loan and avoid the foreclosure altogether, or the receiver can work to stabilize the income from the property to actually maximize the value of the property when it does go to the foreclosure process. It is a little extraordinary. You have to engage a receiver, which will be appointed by the court, who has experience in dealing with and managing the type of property you're involved with in that situation, but it is one additional remedy available to you. In addition, many times lenders are interested in doing a workout with a borrower that has had problems. There are many advantages to doing a workout over immediately going to foreclosure. If you have any title problems that can be corrected by the cooperation of the borrower, a workout agreement is an excellent vehicle for taking care of those title problems. You can make part of your workout agreement the obligation to cure the title problems, so if and when you go to foreclosure in the future, that title problem is gone. You also have the ability to wipe out all potential past sins by the lender. If the borrower is claiming the lender has defaulted themselves, or they've taken overreaching action to the detriment of the borrower, in a workout agreement, you can have all of those claims waived, and then when you do go to foreclosure at some point in the future, you have a clean proceeding that is not burdened by those past actions at that time. You also have the ability to call upon the circuit court to help you in your process. I've already mentioned having a receiver appointed even though deeds of trust can say a receiver can automatically be appointed, it does require court action no matter what, because the receiver is required to report back to the court on their activities. So you will need court involvement if you are having a receiver appointed. At the same time, there may be a title issue or some other problem with priority that you cannot determine on your own. And if that's the case, you can file an aid and guidance suit with the circuit court and let the court make a determination on the issue you bring before the court, and the court will then issue an order that will decide the issue, typically gives the trustee the roadmap to a successful foreclosure, and protects both the trustee and the lender in proceeding with the foreclosure so long as you follow the procedures and information as laid out by the court. So an aid and guidance suit can be an invaluable tool in solving problems that you encounter in a commercial foreclosure proceeding. As with residential foreclosures, in commercial foreclosures, there's always the possibility that the debtor is going to file bankruptcy. My experience is the filing of bankruptcy, if it's going to happen, always happens the night before your scheduled sale or the morning of your scheduled sale. So I always make it a practice to check and see if there's been a bankruptcy filing by the debtor at both of those times, the night before my scheduled sale and then the morning of. As you know, with the automatic bankruptcy stay coming into effect upon the filing of the petition with the bankruptcy court, it would stop your proceeding. Therefore, it's best to check to confirm that there has been no proceeding. This protects you as the trustee, it protects the lender, and it protects your high bidder at the sale when they take the title to the property. If there is a filing, that does not necessarily mean that that is the end of the matter. You can still have a foreclosure sale proceed once you receive relief from the automatic stay. So if there's a filing, you need to have a discussion with the lender as to whether they want to proceed to seek relief from the automatic bankruptcy stay. And if the facts are such that you can satisfy the bankruptcy code requirements to obtain relief, then the necessary petition should be filed with the court and proceeded with. There will be an exclusivity period for the debtor of between 90 and 180 days before it can be filed. But if you can file, you can then file once outside of the exclusivity period, and once the order is entered, you can proceed with your foreclosure sale. Now, if there's been a bankruptcy and you receive relief from automatic stay, you should, and I recommend that you get a certified copy of the order granting relief, and that order be an exhibit to your trustee's deed to your purchaser at the foreclosure sale. By recording the certified order showing that you obtained relief from the automatic stay, this will be of great benefit to future title examiners because it demonstrates that you did go through the process and you had relief from the bankruptcy stay before proceeding with the foreclosure sale. It will be invaluable in the long run. I briefly spoke about the unique properties you can encounter in your commercial foreclosure practice. Not only does this, and I talked about the need to perhaps expand your advertising so you get a bigger audience and expand the base of bidders for unique properties. Though there are other things that you should take into consideration and make adjustments as appropriate. Your notice of sale and your advertisement may need to include information that is in addition to the bare minimum of what is normally included in the notice of the sale, because you want to advise potential bidders of certain information about the property that would not normally be included in a notice of sale. You may also want to have other resources available through a file share site or some other vehicle to provide information about the property to potential bidders so they can get some information about the property rather than just bidding in the blind. Also, there are certain types of properties where you will want to sell fixtures at your foreclosure sale. The best example is hotels, which are really made up of two groupings of property. You have the real estate, which is the building, but you also need to sell all of the contents, the furniture, the cleaning supplies, everything that is needed for running the hotel is typically encumbered by a security interest in your deed of trust or in a separate document, and you need to sell that at the same time. The UCC code permits you to sell all of those fixtures in a foreclosure proceeding, provided you give the correct notice in your foreclosure notices. So be aware of, are there any fixtures that need to be sold with your real property? And if there is, follow the procedures as outlined in the UCC code, incorporate them into your notices and advertising before your sale. Lastly, you'll also need to make appropriate announcements at the time of the sale to apprise the bidders of what's going on. So now I've covered some tips and traps to avoid in your commercial foreclosure proceeding. Next, Vanessa and I will go over some issues that can come up in both commercial and residential foreclosure proceedings. Thank you.